Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3048, United States of America versus Maxine Williams, appellant. Ms. Bitterman for the appellant, Mr. Hansford for the appellate.
Good morning, judges, Childs, and writers. My name is Donna Biederman, and I am here representing the appellant, Maxine Williams. Ms. Williams was not afforded constitutionally effective assistance of counsel in this record. And we have identified 3 ways in which she was not afforded constitutionally effective assistance of counsel. The first way is that her attorney never met with her in person. The second way is that she was not told she could be in court for sentencing, which she has stated she would have chosen. And the third way is that her attorney did not ask for any character letters. At the very least, we presented a colorable claim here that requires a hearing. This court and other courts have consistently held that ineffective assistance of counsel claims typically require factual development in the general district court below, in the district court below. And so we believe that is true here. Now, in the government's...
May I just start out by asking what is the type of relief that we would seek? Because I understand that her period of incarceration is at least over, maybe not the supervised release, but so what would be the relief at this point?
That is correct. She has finished her term of imprisonment. She is on 3 years of supervised release. So what we would be doing is trying to get her plea overturned and for her to be able to go to trial if she wanted to on this. That is what she is seeking.
Okay, and does she understand that if her plea is overturned, then it goes back to the prosecutor to determine what the potential charges could be, including what she had and even the other ones that were perhaps dismissed as a result of the plea agreement?
She does. She does. She steadfastly believes in her innocence and would like this off of her record. And she told me that last night.
Okay, and then even in that regard, aside from whatever might be ineffective assistance of counsel, we still have on the record her actually accepting her plea knowingly, voluntarily, and intelligently with a substantial plea colloquy by the district judge.
I understand. Now, let me go on to the 3 different ways which we've alleged there were ineffective assistance. First of all, her attorney never met with her face-to-face. She had hired him in February of 2021 and February 26th. The information in this case was filed on March 28th, 2021. And 2 days later, the district court set it for a plea, which was taken on April 6, 2021. So it was a very, very short period of time that this attorney actually represented her. And during that time, he never once met with her in person, even though she asked him to. Now, this is an allegation that would lead to ineffective assistance of counsel because it would change her desire to enter into the plea. And it's something that we can't determine on this record. It's something that would have to go back to the district court for an evidentiary hearing in order to determine that indeed they never met face-to-face. And indeed, she had requested that of her attorney. That's the first issue that we have raised. The second issue we have raised was that she was told she could not appear in person and that it's in the plea agreement. But at the hearing, she was told she could appear in person, which took her by surprise because she has insisted that she would have asked to appear in person, and it could have changed the plea as well had she appeared in person. But it was too late at that point. Her attorney didn't inform her of this, and again, that's something that needs to be factually developed. So we have remand. The third point is that there's no character witnesses or letters that were asked for on her behalf. This is a basic but a very important step when somebody's being sentenced. The government has said, well, she didn't have anyone that she could have asked for, but that's their assumption, and it's not something that can be determined by the record. Again, it's something that she would need to testify to in order to be able to say who she would have asked for character witnesses or letters. The government, in fact, has actually identified two people, the first one being her mother, who lives in a different country, but could have given her a letter, and the second one being what they call individual A, and they say he would not have been a good character witness because he was somewhat, or she was somewhat peripherally involved in that some checks were put into that person's account. But that's the government.
Two other points. She doesn't indicate any dissatisfaction with her lawyer on the record. Is that correct?
She does not.
Okay, and then secondly, with respect to the character letters, it appears that the district judge did indicate that this particular offense was out of character for her.
Yes.
But even then felt like the judge did not believe that she could actually give her any sentence below the guidelines in this regard. So taking into the 3553A factors in consideration of the gravity of the offense and the amount of money and the nature and time and significance of several offenses occurring, within this particular charge.
Yes, that is correct. But the character letters could have changed his mind on whether he could have given her a lower.
But the judge also spoke to the fact that, again, out of character, but and spoke painfully, about having to deal with this person in the sense that it is out of character, but just couldn't get over the significance of the crime.
Right, but the character letters that she could have gotten could have helped him to get over that, depending on what had been in them. And that's, one of the things that we need to have developed on the record in order to be able to address.
Her allegations here, Ms. Williams' allegations, she doesn't identify anyone who could have written letters to her, does she?
Not in our briefing, no, she does not.
And so,
other than her mother.
So how does that, isn't that just isn't that too conclusory then to rise to the level?
I don't think it is. And because I think that when we were working on the briefing, she was in jail or about to go into jail, a prison. And I think that she didn't have the time really to figure out what she could tell me in order to put into the briefing. But she could certainly be able to now address that and to know who it is that she wanted to ask for character letters for.
Isn't that ignoring her burden on 2255?
I'm sorry, isn't that what?
Ignoring her burden on 2255. This is not a direct appeal.
Correct. Well, this is under a direct appeal, but it's a direct appeal that is an ineffective assistance of counsel. And yes, I don't think it's ignoring her burden. I think it's understanding the practicalities of what was going on at the time.
Well, anybody could say they could get letters.
Well, that's what we need the hearing for at the district court in order to be able to develop the record a little bit more. I think at the very least.
The district court, sua sponte, doesn't have that obligation.
No, she wants to have the opportunity to do it at the district court. Now, the government argument, it's mostly assuming.
Ms. Lieberman, can you point to anything in the record, though, that overcomes the strong presumption that her counsel was acting within the wide, reasonable professional assistance, right, which is the standard? What was outside the reasonable range of professional assistance?
I think
failing to ask for letters.
I think what was outside of it was the three things that we have identified. The first one is that he never met with her in person. That is clearly outside of a reasonable attorney's representation. And the second one is the character letters. And the third one is this issue of her not being told she could be in court until she got to the sentencing and she was telephonic and it was already too late. I do want to just quickly mention, I think that the government arguments are all assuming the plea was the only reasonable response based on the evidence, but that's not a factual assumption. That's just, or not a factual statement. It's really an assumption more than anything else. The government is deciding that he couldn't have done anything else rather than allowing her to present evidence otherwise. I would like to reserve the rest of my time for rebuttal unless there's any other questions. Thank you.
Good morning, and may it please the court, Eric Hansford for the United States. The record in this case shows that there was no deficiency by counsel, either in the plea or in the sentence. In any way, there was no prejudice. This court need not reach those issues because there's a preliminary problem, which is that in her briefs on appeal, the defendant has not even alleged that there was prejudice. And that pleading failure means there is no basis for a remand under the Supreme Court's holding in Hill, as well as this court's multiple decisions cite on page 20 of the brief, like Horn, Tucker, and Muhammad. And for that reason, this court should affirm. This is, just to clarify, this is a direct appeal. This is not a 2255. And as far as we know, the defendant has not filed a 2255, although the time has not run on that.
I understand that. My question was going to what is her burden? That at this point, she never raised it. Normally, she'd be in a 2255 situation. She's trying to get under the more liberal standard under a direct appeal, but she hasn't put anything in the record. That's the point I was trying to make. So that's the burden. I don't understand how she meets it.
No, we certainly agree that she does not meet it. And even before you're getting to burdens and what sort of evidence there should be, she needs to make these kind of basic allegations. That's what the Supreme Court says in Hill. And she needs to make these allegations in a non-conclusory way, which is what the Tucker court goes through, this court in Tucker goes through. The defendant's allegations here are similarly conclusory to the allegations in Tucker, where this court said, for example, the allegations in Tucker where there was an alleged failure to investigate potential other witnesses. This court said, we don't need to remand that because she hasn't identified any actual witnesses. That defendant in Tucker hadn't identified any witnesses. And it's similar here with the character letter.
But isn't the government also being conclusory when you make a statement that says no one credible could write a character letter for her? Isn't that an assumption?
I think we're saying the record as it stands. We're not saying it's impossible that she would be able to find someone who could write a character letter for her. We're saying the record as it stands indicates no one credible. And that's not just because of the absence of evidence. That is because she is repeatedly saying during the sentencing colloquy that she has no family, she has no one close to her. She says she only has her support dog, that she's been out of contact with her mother, this individual A, who she's now identified at argument as a potential source of a character letter, was caught up in the scheme. This was someone who she was also depositing checks into that person's bank account. And so I believe it's the district court. It's either the government or the district court in the release litigation says that's not a credible person to provide a character letter. But I think the more important point is what you were saying, Judge Childs, earlier, which is that the sentencing here was based on the conduct, not the character. And indeed, the judge said repeatedly, we recognize this is out of character. This does not seem to reflect who you've been for your life, but the egregious conduct in this case is the reason that I'm imposing the sentence that I am, what the judge said. So based on that, we don't think she'd be able to show prejudice based on the last.
But you would agree that character would be one of the 3553 factors, the history and characteristics of the defendant.
That's right. That's certainly true. Yes. We do think just these, before we get into the merits, we do think these pleading failures under this court and court precedent, a remand in this case, and her failure to offer any actual allegation here alone should be a basis for affirming this case.
The failure to allege prejudice, or
That's correct. Her failure to allege.
what about the failure of the attorney to meet with her in person? What would she have to allege, do you think, to get past this stage?
So I think in order to, it would be different for deficiency or prejudice, but she would have to be identifying things that reasons that she wouldn't, that the failure to meet with her in person would have hurt her. So in other words, things that couldn't have been conveyed via Zoom meetings, but would have been conveyed in person. Remember, this is March, February of 2021, a time when very little was going on in person. And so we have a specific statute from Congress recognizing that, saying in remote sentencings, pleas are acceptable. And so this is a time when it was perfectly appropriate for counsel to be meeting remotely with their clients.
So you think there was no deficiency?
We think there's no deficiency in being remotely, at least for this sort
at
of
that time
pre-indictment plea. There may well be an argument that if you were preparing a client for trial testimony, that maybe at that point you should be meeting with the client in person. But that's a very separate issue from kind of what conversations need to be happening with a pre-indictment plea. And also she would have to allege some reason to think that would cause prejudice. In this case, she just hasn't alleged any reason to think that would cause prejudice.
And there were several opportunities before the plea date in terms of the proffer and.
That's exactly right. There were several opportunities, and she's repeatedly during the plea colloquy, as well as in the plea itself and at sentencing, expressing, saying she's happy with counsel, with the services that were provided by counsel. And so she would have had many opportunities. She didn't want to go forward with a plea. She was not being forced to go forward with a plea. She would have had opportunities to change things around. And indeed, she did change counsel. She retained this counsel a month before the plea. And so she clearly knew that she was able to, she was unhappy with counsel, change counsel. She obviously did not pursue that. And so there are no further questions. We'd ask this court to affirm.
I have just a few things I would like to address on rebuttal. The first one is that the government has mentioned and mentioned in its briefing that she was out of contact with her mother. That had only lasted for a couple of months. It's not like she was forever out of contact with her mother. It was just for a couple of months. And there isn't anything on the record that explains, that talks about how long it was or whether that was something that could be remedied. And again, that's another reason for a hearing. The government stated that I identified individual A as a possible character witness, but that's not what happened. I said that the government in its paperwork had identified individual A as a possible character witness. I was not identifying him myself. I had mentioned that that's what the government had mentioned in their brief. As for identifying reasons that the failure to meet in person would have made a difference, we did do that in our briefing. We did mention that that sort of a thing makes a difference as to how somebody comes across on the stand and how a judge or a jury would react to them. And that's not really possible to effectively represent somebody without knowing how that would be. Now, the government has mentioned just now, there's no evidence in the record. The government said that there's no evidence that a face-to-face would have been different from a Zoom. There's no evidence in the record even if they had even a Zoom meeting. The point was that he only spoke to her by the telephone. And the government said that if it was preparing a client for trial, it may have been deficient not to meet with her. But the point is you can't decide whether you're going to go to trial or take a plea without being able to see somebody face-to-face. And to just say, well, if they had been preparing for trial, it could have been deficient, suggests that it's deficient here as well because they don't know what they're going to be doing. For all these reasons, and any others that are obvious in the record that say that we have made allegations here that are non-conclusory, and we would ask for reversal and a remand to the district court for hearing. Thank you.
Just one quick question that just kind of came to my mind. I mean, how much weight are we to put on the judge's statements below in terms of everything that the judge went through with the plea colloquy as well as the sentencing factors to ultimately lead to the outcome? Because again, that's kind of a prejudice prong too, from the standpoint that the participate in that entire process.
Correct. So which statements are you referring?
Well, I'm just talking about just generally the plea colloquy led her to that voluntarily, intelligently, and informed decision because the judge extensively, went through all of these questions. And at any point, there could have been an opportunity or some kind of hint of dissatisfaction, of not understanding, of having concern about what she was pleading to, but she accepted responsibility for all of, the issues that were there, and then also had lesser charges. So how much weight are we to place on what has already occurred versus what she's raising now after the fact?
Well, Your Honor, I think that the fact that it was held by telephone and that she wasn't in the room affects that, as it definitely affects the weight to be given to it, because it's different if you're in the room and you're talking to the judge and you're there and you can say, wait a minute, hold on. In the sort of Zoom and telephone conferences we're having at the time of this plea, it's a lot harder to do that. A lot harder you can't make facial or hand motions or stop somebody as easily. And so I think that definitely affects the analysis there. Thank you.
Thank you. Case is submitted.
Case number 20-7032, Alexander J. Bastani et al., appellants versus American Federation of Government Employees, AFL-CIO. Ms. Jenkins for the appellants, Ms. Alves for the appellate.
Morning.
Good morning. In police and court, my name is Eleanor Jenkins, and I represent Bastani et al. Because of my limited time, I'm going to get straight to it. Our first objection on the trial about the trial court's decision was that they summarily dismissed two of the plaintiffs, Lauderdale and McCarran, and they relied on the case Himmler out of the Southern District of New York. They didn't have to rely on it, but the trial judge relied on that case. That case is inopposite to what was done here. It was not a full and fair feathering out of whether there were material facts before he granted summary judgment and dismissed two of the complainants.
Wouldn't you agree that the motion to dismiss standard and the summary judgment standard are different? I mean, motion to dismiss, we'd be looking at the...
I really could hear that.
Sure. Wouldn't you agree that the motion to dismiss standard is different from the summary judgment standard? In other words, on the motion to dismiss, we're looking at complaint and sufficiency of allegations, but by the time you get to summary judgment, you would have gone through interrogatories, responses, depositions, et cetera.
That is
and
true.
That's the evidence at that time.
That is true. We had gone through the interrogatories. We had gone through pre-trial hearing at which the trial judge did not allow Ms. Lauderdale to testify. He said, we're going to take testimony only from Mr. McCarron, and it's going to be very limited. We're not going to take testimony from her. So there was no feathering out of a lot of the issues before he got to that.
But what I'm trying to get you to do is focus on the point in time of the record. In other words, motion to dismiss, again, relying on the complaint, and then summary judgment. What is the evidence that has been developed up to that point that the judge gets to assess and determine if there's any genuine issues of fact versus what's then at trial, which is actually testified to and things of that nature?
Right. What had been developed at that point, interrogatories had been taken. There was not a whole lot that had been developed at that point in time.
But and then that's my point too, because then Ms. Bastani is thinking into the future about what would be developed for trial versus what the judge's limited record is at that point in time.
Yes, that's true. That's true. Bastani et al. Was always figuring we're developing this as we go. And that may have been an error on their part to think that this is going to develop as we go. But then the trial judge then held back because they knew there was going to be a pre-trial hearing. And then he did not let one of the plaintiffs even testify there. He said, I'm taking very limited testimony. And he limited that as well. Can I move on? Because I really want to get to the real central point is that this case was tried. The principals, J. David Cox, who took the action against the union president, vice president, and treasurer. J. David Cox was the president of AFGE National. He took the action. He put in place a trustee, Nate Nelson, to carry out the trusteeship. Neither of these individuals, though they were listed early on AFGE's witness list, neither of them came to testify. Now, what you have from AFGE now is that, we didn't object, that Bastani et al. Did not object. However, we went back in the record and it's quoted in our reply brief. We put the whole objection in the record that, in the brief, that the attorney, Mr. Keating, went on at length as to what he would have done to get Mr. Cox here in order to.
Ms. Jenkins, even if you preserved it below the trial court, even if you preserved the issue in the trial court, can you point to where you preserved that issue?
Yes, exactly.
In your opening brief to this court?
Appendix 220, 229.
No, but in your opening brief to this court.
Oh, in the opening brief to this court?
Yes.
Okay. Let me see. Okay. I'll find it. Okay.
The only place that I see it.
Excuse me?
The only place that I see it is in the statement of issues on page 2. But
What page are you looking at?
I'm just wondering if there's, I don't see this point developed further in the actual brief.
In the actual brief, in the reply brief, I think that what I considered was that it was not clear enough that we had made the objection below. And so what we did in the reply brief was quoted it. instead of just referring to it. We gave the entire quote on page 6. We quoted the language from the transcript of what Mr. Keating had to say about it, because we did state that, and I can't find it exactly right now, but I will refer to it later if you need. We did object below. And I think
Wasn't the government's point that you are focusing in, even in your reply brief, and of course the government didn't have a chance to respond to this yet, that what happened at one point, but then the matter proceeded before the trial court, and at the end of that further proceeding, defense counsel presented no objection. Would you agree with that?
defense counsel, I don't know what they did at that point. What happened is after the judge ruled, and that's around A 232, 233.
I'm focusing on what happened after that. The court.
After the objection was made and the trial judge ruled that he would allow the case to proceed without Mr. Cox and without Mr. Nelson, then counsel for Bastani said, I have to do what the trial judge has said to do, to go ahead with this process of allowing actors to read the deposition into the record. He said, I have to go along with it. What could he do at that point but do what the judge had ordered? That this information was coming in. It was coming in without Mr. Cox, without Mr. Nelson, and there was nothing else that plaintiffs could do at that point but to lay the objection there, to bring it to this court. But there was nothing that they could do in the district court.
Counsel, why, do you have an idea why the claims of Bastani and the others was not framed as a freedom of association claim?
I don't know, and that's one of the things I wanted to say about Himmler, that the judge relied on Himmler, but one of the concepts in Himmler is that there can be this distant group, that you're a faction, that you're seen that way in union political alleys. And that's how you are perceived. And that's how the case was presented, that whatever Bastani was doing, whatever President Cox felt about Bastani, he felt about the people who had run on Bastani's ticket and the people who were in process with Bastani, and that was Lauderdale and McCarran, that they were a triumvirate.
Any further questions? Ms. Rogers? Yeah.
No, thank you.
We'll give you a couple minutes on rebuttal.
Okay.
Good morning.
Morning.
May it please the court. Denise Duarte Alves on behalf of the American Federation of Government Employees. The court should affirm the district court's decision to dismiss plaintiff appellant Lauderdale and plaintiff apparent McCarran's claims and affirm the jury's verdict in favor of AFTE for 3 reasons. First, the district court did not abuse its discretion in finding Mr. Cox unavailable and allowing excerpts from his deposition and testimony from the evidentiary hearing to be read to the jury. Moreover, plaintiff appellant failed to properly preserve this issue when they did not object to the lower court's ruling, nor have they raised the issue in their opening brief before this court. Second,
Counsel, I think the reply brief shows there was an objection. At least there's a way to read the attorney's comment that he was preserving the objection. And then they proceeded to this next phase, the alternative way of presenting the evidence. So to that extent, it could be read most favorably to the defendant that there was an objection. But that doesn't respond to your point about there was no abuse of discretion.
Your Honor, if I may, I would explain in response to your statement that the objection that was made by plaintiff appellant's counsel was, and if you see the colloquy that takes place between the judge and plaintiff appellant's counsel, there is this colloquy that is addressing Mr. Keating's concerns regarding Rule 804 of the Federal Rules of Evidence, but specifically with regards to A5. And there you see where Mr. Keating is expressing concern that under the Federal Rules of Evidence, the proponent of testimony, where the proponent of testimony would be responsible for procuring the witness. And Mr. Keating expressed concern that that AFGE had not attempted to, in fact, subpoena Mr. Cox. But the important point here is that even though Mr. Keating, in fact, expressed that issue and that concern to the court did not rely on that and expressed to Mr. Keating that he opposed that argument, and that argument, in fact, was not the reason for his decision.
I'm not really taking issue with the way you want to read the record. All I'm suggesting is that there could be a way to read the record that is more favorable here to the defendants, but I don't think that responds to the argument that there was no abuse of discretion here, given the nature of abuse of discretion, where alternative reasonable options are not an abuse of discretion as opposed to an error of law. That was the only point I was making. So it's not unusual to read records where counsel says, I'm not surrendering my objection, but moving along, what can I do? The trial court has ruled he wants the evidence to come in. And so I take your point about no objection to A4, only to A5.
But I think an important point here is, yes, no objection to A4, an objection to A5. But at the moment that the court then issued its ruling saying that Mr. Cox was unavailable, according to Rule 804 A4 under the Federal Rules of Evidence, Mr. Keating could then object on that basis. And a review of the records.
Counsel, we're agreeing.
I'm so sorry, I did not hear you.
I'm not disputing your point. I'm just offering an alternative view, but I don't think it's worth pursuing here.
Understood. Thank you for clarifying.
Can I just ask you an actual question? Who was Mr. Stennis? Who was he? Mr. Stennis, who read Mr. Cox's testimony, who was he?
Mr. Stennis is an employee of AFGE. He's an attorney at the Office of the General Counsel at AFGE. So aside from not objecting, with regards to, in order to preserve the issue, the plaintiff appellants also did not object to the lower court's ruling. They have not raised this issue in their opening brief here before the court. The second point I wanted to make as to why the decision should be affirmed is that the district court properly dismissed plaintiff appellant's Lauderdale's claims because there's no specific evidence in the record showing that she engaged in protected speech. And it properly dismissed McCarron's claim because there was no evidence in the record showing that Mr. Cox or Mr. Bunn knew that McCarron had engaged in protected speech. And three, the court should reject appellant plaintiff's arguments which were not raised with the district court or which are not supported by the record. And even if they were, it does not provide the court with the basis to overturn the district court's decision. I would like the opportunity to address a few points that Ms. Jenkins raised. I would note that Ms. Jenkins is one and the same with Ms. Lauderdale, who is plaintiff in this case, one of the plaintiffs. There is, when you are looking at the moment that you find that a witness is unavailable pursuant to 804A4, the testimony that was brought in and read by Mr. Senes, the deposition, the excerpts from the deposition that were also read by Mr. Senes, those were excerpts of the deposition and of the evidentiary hearing where plaintiff appellants, their counsel had an opportunity to cross-examine, to ask questions of, in fact, Mr. Cox. So to the extent that there's an argument that plaintiff appellants are making an argument that there was harm in Mr. Cox, his testimony and the excerpts of the deposition being allowed into the record and him not being deemed unavailable, it is AFGE's position that there was no harm. I would also like to address that aside from the court not abusing its discretion in finding Mr. Cox unavailable, I would like to bring to your attention that in plaintiff appellants' opening brief, they did not, in fact, raise the argument properly before this court with regards to preserving their argument as to 804A4. If you look at the opening brief, specifically with regards, I would direct the court's attention to page 13, you will see that there is no mention of, no argument addressing 804A4. In fact, they don't address 804 at all. In the opening brief, they now modify their argument, change their argument to, in fact, not object or not address whether or not the court erred in admitting or allowing the transcript and the deposition to be read to the jury. And instead, now they're arguing that the court, in fact, erred in allowing Mr. Cox to hide behind the 100-mile limit of enforcing subpoenas. And in fact, then it appears to argue a violation of Federal Civil Procedure 45C1A. I would finally bring to the court's attention that ultimately plaintiff appellants have not shown that they were harmed in this case. First, as I already argued, plaintiff appellants had the opportunity to depose Mr. Cox, had the opportunity to cross-examine. We did have an evidentiary hearing where he was questioned. The court provided instructions to the jury with regards to how to treat the testimony that was being introduced and read to them. Moreover, plaintiff appellant's counsel was given the opportunity to, in fact, argue to the jury in its closing arguments as to the ability to consider Mr. Cox's unavailability and to, in fact, question the credibility of what was heard by the jury. In conclusion, we would ask that this court affirm the district court's decision to dismissing Lauderdale and McCarran's claims and affirm the jury's verdict in favor of AFG.
Thank you. Ms. Jenkins will give you 2 more minutes.
I think I heard that AFGE saying that the objection was not preserved. I think that's what I heard. And Mr. Keating, and we laid it out in the reply brief, but Mr. Keating also added, and we couldn't put everything in the reply brief, he noted, and this is at Appendix 231, that the fact that Cox was not here and that Nate Nelson was not here, that it deprives Mr. Bastani of the right to have the jury review all of the key witnesses in person. This is not what the rules intended.
Ms. Jenkins, I think you would do best to focus on whether you've preserved this argument in your opening brief rather than as an objection below in the trial. Can you point to where it's been preserved in the opening brief?
In the opening brief.
Before this court?
You know, that may have been, I don't see it written in the opening brief, but that's why you have a reply brief. We did not know that they were going to say that it had not been preserved. So there was no need to sit and do a recitation of we reserved this, not until we got our police brief did we know that that was in contention. It was very clear as much time as was spent on this, we didn't know that they would make that a base argument because it shouldn't be, because it was clearly preserved. It clearly was. So no, we didn't expound on that in the opening brief. We didn't feel it was necessary, but when we got their brief, we said, well, that's a major contention and we've got to address it. And that's why I think the system is set up, the rules are set up so that you can have a reply brief and you can get to those elements that you didn't in the first one because you did not know that they were in contention.
Any further questions?
And let me just add that yes.
Ms. Jenkins.
They spoke about the deposition testimony coming in, but I think it's crucial that people, and I'm sure your judges, you understand that that does not give the jury an opportunity to judge the witnesses. What they had, instead of Nate Nelson, they had acting for him, what's her name, Keisha Williams, who is a trained attorney. They had an attorney giving testimony for a man who knows absolutely nothing about the law, who is not as well-spoken as her, who is not as bright as her, whose demeanor is totally different than hers. How can the jury judge the demeanor of that witness, the truthfulness of that witness, anything about that witness?
Thank you, Ms. Jenkins. You're out of time. Thank you.
Thank you.
Yes, the case is submitted.
Case number 21-1018 et al. State of California et al. Petitioners versus Environmental Protection Agency. Mr. McCombs for the petitioners, Ms. Coleman for the respondents, Ms. Berman for the interveners.
May it please the court. Peter McCombs for the state petitioners. With me at the table is Sarah Burke for the environmental petitioners. I'll be presenting argument for both. I'd like to reserve 5 minutes for rebuttal. In 2016, EPA determined that climate change driven by greenhouse gas pollution, including pollution from aircraft, represents an extraordinarily severe threat. Nevertheless, in adopting the 2021 aircraft rule, EPA refused to even consider adopting aircraft greenhouse gas emission standards that would reduce these emissions by any amount. EPA expressly refused to consider the climate change impacts that show the need for greater than zero emission reduction, stating, "We do not address in this rule the potential environmental or other impacts requiring reduced airplane emissions beyond adopting the ICAO CO2 standards," ICAO being the International Civil Aviation Organization. EPA confined its technology review to validating the ICAO standards, which it found had no cost, no benefit. EPA restricted its analysis to standards that required no improvement from the industry at all.
So isn't the question before this court, having acknowledged the points you have just made, was the agency's explanation of what it did here reasonable and supported by the factual assertions it made? And haven't we already decided that question in the National Association, the NACAA case of this court?
No, Your Honor, and NACA actually supports our statutory arguments, and it never reached any.
That's not the statutory argument. I'm trying to decide here.
Well, as for our arbitrary and capricious argument.
No. Understand what I'm saying is that the agencies have an obligation to follow the law. But the Supreme Court and this court have long recognized that the agency can also offer an explanation as to what it is doing in response to objections that have been raised, much less to what the statute says. And the question before the court is not whether the agency could do nothing other than confess error and stop the ongoing rulemaking proceeding. That is not what the Supreme Court has held. It's not what our court has held. And so don't we have to, even assuming the truth of what you say as to what the statute requires, whether or not what the agency did here was nevertheless legally permissible, I'll put it that way, because of the explanations it gave for why it proceeded to promulgate the rule as it was, stating that there were reasons to go forward in its view now with the idea that work had to be done so they could catch up later. I mean, I'm just trying to focus on what is the issue before this court.
So even when the agency is explaining its reasons, it still has to consider important aspects of the problem. It still has to consider obvious alternatives.
Well, what I'm saying though, Mr. McCombs, is yes, but here when the agency offers an explanation as to what information it would require in order to do the exact examination you state is required, the agency is acknowledging this later promulgation. So it's not denying it, it's simply saying we're not in a position to act on that now. And don't we have to decide whether that was a permissible course of action for the agency?
Yes, and I think there are a few tools that this court would have to decide that question. One is that explanation arbitrary and capricious under the State Farm standard? I think the other would be, is explaining why one didn't consider the statutory factors a substitute for considering statutory factors? I think the answer is no to that, because EPA is...
In your view, what did the agency have to do here? Where it acknowledged it didn't have the information it required, that the latest reduction was promulgated fairly recently, and it needed more time. The agency, just had to stop the ongoing rulemaking proceeding?
No, the agency had plenty of time to conduct the analysis that we urged it to. So the ICAO
agency responded that it needed more time, apparently, than you suggested, because a couple of months wasn't enough.
But that doesn't hold up on the record, Your Honor. In 2017 was when the ICAO adopted its standards. The proposal didn't come out until 2020, and in that 3-year time period, EPA did conduct a technology review with a very sophisticated model. It conducted its alternative analysis, but it chose to restrict those analyses to simply validating the ICAO standards instead of looking at what could feasible technology actually produce in terms of emission reductions. So it never used that time.
Agency said in order to make that type of determination, we need some other information, and we either have to stop ongoing proceeding or remain out of compliance for a longer period, remain out of partial full compliance for a longer period.
Two responses, Judge Rogers. The first is that the agency has been developing a record, or it's been collecting information at least, on these technologies and measures for aircraft since 2008. So it's been gathering information for 12 years before this rulemaking was initiated. Second, the deadline that EPA is citing doesn't hold up on the record either, because the soonest any aircraft we know of needs to be certified to these ICAO standards is 2028. There are no new type aircraft on the horizon that need to be certified to the new type standard. Only the in-production standard could present that disruption effect that EPA is worried about.
And so what do you do about that?
Well, in the 8 years that were between 2020 and 2028, EPA could have studied obvious alternatives like emission reducing. It left the entire range of emission reducing alternatives from 0 to 100% emission reductions completely unexamined. We suggested in the record that a standard that's 10 to 20% more stringent than ICAO's top stringency level would be an obvious alternative from the face of the record. But EPA left all of that unexamined. That's...
Just one follow-up quickly. What do we do with both the Supreme Court and this court's precedent that gives great deference under the statutory language here to the administrator and the agency's determination on these technical matters?
2 points, Judge Rogers. First, the agency certainly does enjoy a great deal of discretion over these technical matters, but that discretion has to be reasonable, it has to reflect the record, and it has to be exercised in accordance with the Congress's priorities in the statute. So it has to be exercised with the statutory factors. EPA did not do that here.
No, but you have basically to say to the administrator, we don't believe you when you say you need more time to examine the cost effects.
Correct. The record states otherwise very clearly. Moreover, this court has stated on many occasions that even a time crunch or a perceived time pressure doesn't justify an arbitrary rulemaking. It doesn't justify skipping over the statutes that Congress specified in Section 231. But that's what EPA did here.
Maybe in part in relation to Judge Rogers' question. I mean, Section 231 is extremely open-ended delegation to the administrator. I mean, that may pose problems of its own, but this court in the NACAA case has explicitly rejected the idea that Section 231 requires a technology forcing approach, which is what the petitioners argue is required here. So I guess I'm just not sure how your statutory argument can be squared with what was specifically decided in our earlier case interpreting this very provision?
Certainly, Judge Rao. So NACA stands for the proposition which EPA put forward in that case that Section 231 requires it to identify a reasonable balance of specified emission reduction, cost, safety, noise, and other factors. EPA takes the opposite position here, that Section 231 requires no particular factors to consider. That's not correct on the face of the statute. That's contrary to the position.
Doesn't the rule here read very much like the rule in the NACA case? I mean, in terms of how it considered those other factors? It recognizes that there are other factors, but that adopting the ICAO standards, serves certain important goals for the EPA and maybe for the government at large.
There's an important difference between what EPA did in the 2005 nitrogen oxides rule that was at issue in NACA. There, it considered the statutory factors alongside this harmonization interest, the importance of ICAO standards. What EPA has done here is effectively supplanted the Section 231 factors with its harmonization interest, proceeded solely on that basis. That's not allowed. NACA stands for the proposition that you can add to the statutory factors with these other important non-statutory interests.
What are the factors that are in 231? I mean, there don't seem to be any factors that are in the statute itself.
They're certainly not listed very, they're not listed out in bullet points, but if you look at...
Are they listed at all? I mean...
Yeah, so if taking the first factor, the danger of the emissions at issue, that appears in A1, A2, and A3, where Congress is saying, EPA should understand what are the impacts of these aircraft pollutants, and it should regulate the dangerous ones. This court has held that that kind of endangerment trigger is not just a procedural activation, it's also a policy guardrail. The feasibility factor appears in A1 and B, where it says EPA needs to give enough lead time so that aircraft manufacturers can develop and apply the requisite technology. You can't do that analysis without understanding what is the technology that needs to be applied in order to achieve this emission standard. The noise and the safety factors, those are under A2, B2. The lead time and cost factors are under subsection B. So reading the statute as a whole, as we do, those are certainly the priorities that Congress set forward in the statute. And EPA has interpreted very similar language in Section 202 to do the same thing. It says, a very similar lead time provision in Section 202 obligates us to study technological feasibility. Here, EPA did not do that. It said we did not develop a record on these technologies. We did not gather the data. We did not conduct the analysis, even though it had been gathering information on these technologies since 2008.
To that point, is this essentially a placeholder rule in the sense that you're basically adapting to international standards, but there will be other statutory factors?
So assuming that, I'm sorry, Judge Childs.
Or considerations?
Assuming that there was some sort of first-in-kind benefit or table-setting benefit to these standards, EPA was still obligated to consider whether it could achieve those benefits as well as emission reductions, as it has in every prior first-in-kind greenhouse gas rule. The power sector and vehicles has always been able to inaugurate a greenhouse gas emissions regulation program with very real emission reduction benefits, and it could have done so here as well. The record shows that even current aircraft in the air are outperforming these standards on a scale of decades, and yet it didn't even look at it.
But your main argument requires us to reject the government's interest in harmonization, in a way.
I disagree, Judge Rao. Harmonization can certainly play a role in these standards. What it can't do is supplant the approach that Congress enacted into law. So in the NACA case, for example, it cited George E. Warren Corp. as a great example of how to do this, where the EPA was addressing both a statutory objective of cleaning up the air with this reformulated gasoline program. It also had to comply with the WTO ruling striking down this rule. And so there you had a statutory objective and an important non-statutory interest. And EPA was able to design the program so that it achieved both.
Well, that could be one approach, right? But I mean, is it an approach that the agency has to take? I mean, why is it unreasonable for them to suggest that harmonization is important, for all of its various goals and the role that it played in setting these standards with ICAO?
It certainly can say that harmonization is important, but it still has to ground its approach in the statutory factors or in the priorities that Congress put in Section 231 alongside the harmonization interest. That comes from this court's decision in NRDC versus EPA when it says that EPA has to proceed on rationales grounded in the text and cannot proceed on rationales divorced from the statutory text. That also comes from the independent tanker owners case where Judge Bork pointed out that you can have these non-statutory goals, but you can't pursue them to the exclusion of the objectives in the statute. Here, that's what EPA did. EPA, the objective of the statute is to reduce dangerous pollution. EPA literally did not consider doing that.
But can these be addressed later in upcoming rules?
No, Judge Childs, because the rule has to be judged on the record before the court, and it has to stand up on its own right. It's too speculative to say we can get to this later. In NACA, that's essentially the argument that EPA was making. This court never reached that argument because the petitioners had forfeited their arbitrary and capricious arguments. It turned out that that EPA took another 7 years to adopt that rule that it was just around the corner from adopting. So it really is too remote and speculative to say they'll do a better job next time. We have to judge the job they've done this time according to the standards of Congress and the arbitrary and capricious standard.
And you would say the information was available, but then they would say they didn't have enough time, and so they explained their rationale as to why they didn't look at certain data and other information.
Yeah, I think the reasonable explanation is not the right tool to look at the record here because they still need to consider important aspects of the problem. They still need to consider obvious alternatives. Here, no one disputes that the threat of climate change and the means of reducing aviation's contribution to climate change are the central aspects of the regulatory problem. And yet EPA concedes it considered neither. Expressly did not consider the environmental impacts, showing the need for greater than zero emission reductions. It did not develop a record on the technologies and measures it had been studying since 2008. All of that goes to show, instead it just turned away from that evidence and tied itself to the ICAO standards. And that crosses the line of reasonableness. I'll reserve the balance of my time for rebuttal if the court has no more questions.
Okay, thank you.
Morning, Your Honors. May it please the court, my name is Chloe Coleman on behalf of the United States Environmental Protection Agency. With me at counsel's table is Agency Counsel Rosemary Caban and Intervenor Counsel Amanda Berman. This case concerns the first ever EPA regulation to limit greenhouse gases from aircraft. And as you've heard from petitioners, EPA has inaugurated this control effort by adopting standards that the United States negotiated at the international level that fix into law the industry's pre-existing efforts to reduce aircraft emissions of greenhouse gases. And before I get into greater detail, I want to highlight in two broad strokes why we don't think petitioners' claims of unlawfulness and unreasonableness are valid. As to lawfulness, we think that question is answered by this court's consideration of Section 231 in the National Association of Clean Air Agencies case, also known as NACA. There, the court reviewed a nearly identical rulemaking addressing nitrogen oxides and concluded that EPA's adoption of a standard that would not reduce emissions beyond what aircraft were already accomplishing, and that instead aligned domestic requirements with international cooperative standards, was lawful under the Clean Air Act, because the discretion granted EPA to set appropriate standards under Section 231 is, quote, both explicit and extraordinarily broad.
Ms. Coleman, can you explain a little bit more about why harmonization was so important here to the EPA as opposed to considering ways to exceed the ICAO standards? I mean, ICAO requires the United States to meet those standards. Why is harmonization more important than perhaps trying to exceed those standards?
Well, Your Honor, I think the first, element here is that these are the first ever standards, right? We're inaugurating a program and we're dealing with a global industry and we're dealing with a global pollutant. And so when EPA is trying to determine sort of where is the right place to start here, we're looking in particular at the fact that there's an international regime that's trying to set these standards, and not just for the United States, but for the entire world. We have aircraft, obviously, that are crossing borders every day, every hour of every day, frankly. And so making sure that domestic and international obligations make sense together is something EPA takes very seriously.
Well, that goes to why it should be the minimum standard. It doesn't go to why EPA shouldn't try to, to exceed those standards, right?
That's true, Your Honor.
Especially when aircraft, according to petitioners in the United States, are already exceeding those standards.
We recognize that, Your Honor, but I think this is a circumstance that has a number of additional layers to it. One is that we know that demand growth in the industry is going to be increasingly coming from nations outside of the United States. So it's especially important here to be thinking about sort of what EPA is doing on the international stage. And as to the specific question of why EPA felt like exceeding the standards might actually interrupt that process, ICAO works in these sort of 3-year cycles, Committee on Environmental Work does. And so we have a new cycle that's going on right now, and that will be issuing new greenhouse gas standards for 2025. And EPA understood when it was adopting these standards that there was a genuine risk in sort of, being the primary lead negotiator of these standards on the one hand, and then immediately abandoning them on the other. And so there was a concern here about EPA's credibility in that international process if we were going to walk away from the very standards that we drove ourselves and negotiated between 2009 and 2017 in quite a lengthy effort. So, I think the concern here about exceeding the standards, at least at this point in time, where we're really trying to get this program off the ground and where we're trying to make sure that, we're taking account both of what's happening nationally, but also internationally, EPA made its judgment call that as a participant in these negotiations, which are often, as you can see, very lengthy, very challenging, that it was important for EPA to be able to stand there with credibility and say, we are pushing these standards. We
So this is sort of a unitary executive, we're trying to harmonize our diplomatic and international efforts with our domestic efforts.
Yeah, Your Honor, I think that's true. And it's, very particular, I think, in this industry where those global effects, are being felt by an industry that's competing globally. What we're doing in those negotiations, what ICAO is doing is redounding very specifically to what the industry is doing, and certainly Intervenor Counsel can speak to that. And as I mentioned, we have a global pollutant here. So considering, sort of the global picture and what we're managing to achieve on a global stage is especially important.
I don't understand your response, though, in one sense. I don't think Petitioner's Counsel is really disputing that. At least that's my understanding. I mean, this is a global issue. There are lots of complicated considerations, but the reasons that EPA gave for not addressing certain of the statutory factors don't withstand scrutiny here, because this is not something that EPA just started to study. It's been studying this for years. It's got a lot of data. And how can the agency just say, well, we're going to postpone this further for harmonization? Harmonization has always been there. I don't understand petitioners to question that at all, but rather that at least under the statute that gives the administrators this very, very broad discretion, there are certain limits. And the administrator couldn't say, for example, I've been working hard for 5 days, so I'm not going to work on this anymore for another 5 days. Rather, it has to look at the statutory factors and tell us why, as to those particular factors, its judgment is it cannot go forward now on addressing this most recent reduction in the global standard.
Well, Your Honor, I would like to make the point first that we don't agree with petitioners' primary arguments as to lawfulness here, that there are specific factors that EPA has to weigh in a particular way. And so when we're talking about what was really the standard by which EPA should be judged here, we think it's reasonableness. We don't think it's lawfulness, and we think that NACA decides that. With respect to the reasonableness of EPA's consideration here, as you mentioned, timing is a major concern. These standards came out in 2017 from ICAO, and there are real consequences to the United States if we don't get a compliant rule in place. U.S. Aircraft can be banned from international airspace if we fall out of step with ICAO. So the timing consideration here is quite significant in terms of what sort of the downside risk is.
But counsel, what I'm trying to get you to focus on, and I understand why you may not want to, but I need to be clear that you understand my question, is you've been working, or not you, but the agency has been working to respond to these initial standards, and the international standards keep getting stricter. And so EPA says, well, we can handle, based on our current research and examination, the international standards up to this last increase. As to the last increase, the agency says, because this is so complicated, et cetera, for all the reasons you say, we need some more time. And the environmental petitioners are saying, maybe you do need more time, but in order to justify that, you have to look at the statutory factors and tell us why the data you have simply isn't sufficient. And I was posing to counsel, well, why haven't they done that sufficiently? And you're saying they don't need to do it. And that's like two ships passing in the night. And I just want to see how you respond to environmental and interveners' argument.
Yes, Your Honor. I think one important clarification here is there hasn't been an updated standard that EPA hasn't adopted. That was the case in NACA, but it's not the case here. At this point in time, there's only one international standard that ICAO has put out for greenhouse gases, and that's the 2017 standard. So there isn't sort of a secondary record at the international level that we haven't considered. What Environmental Council is trying to get us to do is expand our scope of examination into the wide world of infinite other options here that aren't included in the ICAO standard and that haven't yet been adopted in another ICAO standard, although as our brief mentions, we do think an updated standard is coming. And with respect to those, record, whether the record could support EPA's examination on this time frame of those considerations, we think it's very clear from the record that we could not do so in time for this rule. There are, a host of other technologies that are available, but they're not necessarily available for all regulated aircraft. And EPA is trying to set a rule here that applies to the industry at large. And so the question of whether EPA had adequate data to actually go ahead and make cost and feasibility determinations with respect to this, much broader scope of technologies, we think it's very clear the agency didn't have that time to do that here. And I would note that some of those technologies, some of the things in petitioners' briefs, raise really complicated questions. EPA is an unusual position in this part of the Clean Air Act because it has the authority to set the standard, but it doesn't have the authority to enforce the standard. And so all of the enforcement that happens, even of this 231 standard, happens through FAA and its certification processes and its other regulations. And so when you're talking about something like operational standards, petitioner's brief mentions the idea that EPA could reduce emissions by eliminating layovers, which I'm sure we'd all appreciate, or changing how taxiing and takeoff are done. These are things that fall outside of what EPA can actually enforce. Those are things FAA would have to go do.
Ms. Coleman, let me ask you, has EPA ever deviated from ICAO standards for other pollutants, or does EPA always meet the ICAO standards? Does it ever go above or below the ICAO standards?
There have been instances since the sort of start of ICAO standard setting in the 1980s, but for the past 25 years, EPA has been very consistent in adopting ICAO standards and in putting those at the fore.
So then what about petitioner's argument that this is a kind of impermissible delegation to a UN agency of standards, right? So if EPA is just simply following ICAO standards, is that a problem? Or why isn't it a problem? I assume you don't think it's a problem.
No, Your Honor, we don't. And EPA performed its own analysis here. There's a technical support document. There were alternatives considered. EPA is going through its own process to make sure that it ground truths everything that's happening at the international level. I think it's also important to recognize that EPA is the primary driver of the technological and sort of negotiation side of ICAO. So it's not as if it's sort of a shadowy room full of people and the United States doesn't have a role in that. We're really the primary participant in that. So we're doing it at both levels, internationally and domestically, but there is a separate analysis in this record with respect to the cost, with respect to the feasibility. And I think that's an important moment to correct the record as to one thing that petitioner said with respect to NACA, which is that the rule there considered factors alongside harmonization, considered things like emission reduction. And if you actually look at the rule under consideration there, and this is mentioned also in the court's NACA opinion at 1225, the court understood that there was no alternative analysis performed there. EPA did not even consider whether it should set a more stringent standard. It did not consider whether getting additional reductions there would have been valuable. And the court still did not find that a problem. Here we actually have an alternatives analysis. EPA did more than it did in the NACA rulemaking to look at what those reductions would be from these different alternatives, and then supported why this was the reasonable alternative. I see that my time has run. So in conclusion, Your Honors, we would just mention that we dispute petitioner's assertion that this rule does nothing to advance the aims of the Clean Air Act or to ensure the aircraft industry is addressing its contributions to climate change. These standards have had the support of 3 presidential administrations from different political parties. And with these standards, EPA has laid a foundation here that regulates this pollution for the first time, that makes legally enforceable the significant steps the industry has taken to make planes cleaner, and that positions EPA to continue to fight for international action reducing aircraft emissions, not just in the United States, but around the world. As EPA's inaugural rule in its program to control greenhouse gas emissions from aircraft, we think those judgments were lawful and reasonable, and so the aircraft rule should be upheld.
Thank you.
Good morning, Your Honors. Amanda Berman for Intervenors Boeing and the Aerospace Industries Association of America. EPA reasonably chose to align the first ever domestic aircraft engine greenhouse gas emission standards with the international standards to which the US-made aircraft must be certified. And I'd like to focus on 3 points that are key from intervenors' perspective. The first is the unique need for international harmony in this particular industry. And to be honest, Your Honors, I'm not going to say much about that because I think that was very robustly covered by EPA counsel, and we've talked a lot about harmony. The second point is the competitive harm that would result if US standards were in fact more stringent than the international standard. And the third is why it would be very problematic to even require EPA to consider technology forcing standards or standards based on changes in aircraft design or operation. So starting with that second point, because international harmony has been so robustly covered, EPA very reasonably considered the unique history of this particular industry and the market forces that govern it, and the competitive harm that would result from more stringent standards as compared to what applies to our international competitors. No other industry has such a strong economic incentive to reduce emissions, and no other industry has a similar history of doing so. Every new generation of aircraft has been more efficient than the last. EPA noted in both the response to comments and the TSD, and you can see this at Joint Appendix pages 51 and 119, that the cumulative fuel efficiency improvement of the in-service fleet was almost 40% between 2000 and 2019 alone. And that was the baseline from which EPA was acting here, a baseline not of static emissions or increasing emissions, but a baseline of continual improvement. And locking that very significant progress in place is not the nothing that petitioners are trying to make it out to be.
So are your arguments all going to the idea that EPA's decision here was reasonable?
Yes, absolutely, Your Honors. And I can address the statutory arguments as well, although I do think they are addressed by the court's decision in NACA. So I was going to focus on the arbitrary and capricious. And my point is that EPA didn't just consider international harmonization. It also noted the competitive harm that would result if there were a more stringent domestic standard. And I can point the court to Joint Appendix pages 3 and 22 on that. Boeing and other U.S. manufacturers, we are competing one-on-one with aircraft made in Europe and in China. If the standards were the increasing stringency, the 10% that petitioners mentioned here today, the next Boeing plane on the chopping block would be the 737-9 MAX. And that competes against the Chinese aircraft, the Comus C919, which is less fuel efficient. Now, under the Chicago Convention, the U.S. can't impose a more stringent domestic standard against aircraft made abroad, even if they're flying in U.S. airspace. So buyers would have this incentive to avoid the extra cost associated with more efficient U.S. aircraft by buying a cheaper foreign-made product that already is less fuel efficient. So not only are we talking about U.S. manufacturers losing business, but we're talking about lost sales that could in fact equate to an overall increase in greenhouse gas emissions. And I also want to note, Your Honors, that as we explained to EPA when it was promulgating the rule, this rule actually does have a very real impact on Boeing. It's going to put 2 of our planes out of production, the 767 freighter and the 777, earlier than they otherwise would have left production by 2028. Even though right now sales of these are popular aircraft and sales are ongoing. So it does in fact have a very real impact.
What about its determination that there were no costs and no benefits to the rule?
Sure, Your Honor. I think it's important to keep in mind that, again, EPA's baseline in saying that there were going to be no benefits was this assumption of continual improvement at the same rate that we've seen historically. So that's what EPA was measuring against. And we did explain to EPA that there are going to be costs to us. EPA in responding said that it didn't have enough data to verify those. It pointed to the possibility of getting an FAA exemption, which is a process that is still pretty far away here. So we do disagree with EPA on that point that there's absolutely no cost here, because there are costs, at least to Boeing. Your Honors, I also want to point out that it would be very problematic to even require EPA to consider technology forcing standards or standards that are based on changes to design and operation. First off, as we pointed out in our brief, there's an obvious safety issue with technology forcing standards or some of these alternatives that they're throwing out. For example, using only one engine as you're taxiing to take off. If that one engine fails as you're then taking off, there's a real potentially catastrophic problem there. So EPA recognized, and you can see this at Joint Appendix page 22, that safety is uniquely the foundation of this particular Clean Air Act regulatory program. And it mentioned that, it said that in response to petitioners' comments that the rule should be technology forcing. So it's not that EPA ignored the safety factor as they had asserted in their briefs, and I think I heard that again today. The other reason this is really problematic is that the broad approach that petitioners are advocating encroaches on the FAA's authority. The FAA, not EPA, that has primary authority over and expertise in design, operation, and safety of aircraft. That's why it's the FAA that implements any EPA standards through a certification process. And that's why it's the FAA that had the lead in the ICAO process, with EPA serving as an advisor. EPA, in contrast, in Section 231 has a much more limited authority to regulate emissions from aircraft engines. We would thus submit that EPA, frankly, should not be considering or imposing technology forcing standards that would require design or operational changes. That would be a very radical shift in the balance that Congress struck between these two agencies. And EPA recognized that at Joint Appendix page 23, where it noted that this would be unprecedented for it to impose design or operational changes as the basis for its standards. So we submit
So in part, your argument is not that it's just harmonization with international standards, but also with the FAA's domestic responsibilities.
Yes, Your Honor, I want to point out that EPA didn't just talk about harmony. It talked about these competitive harms at JA 3 and 22. It talked about the fact that it would be encroaching on the FAA's authority at JA 23. It's just a bit of a fallacy, this idea that the only thing EPA was considering was international harmony. And international harmony, to be clear, is very important here, and we would echo that. Boeing and other manufacturers need to be able to certify their planes to the international standard. So I see that my time has expired. If there aren't any other questions, I'll conclude.
Other questions? Judge Rogers, any questions? Thank you.
So in conclusion, we would ask that the court deny the petition because EPA's choice to set an ICAO equivalent standard locks in the significant progress that this industry has already made in decreasing greenhouse gas emissions and is a fundamentally reasonable choice. Thank you.
Thank you.
Judge Rao, you asked about if EPA had ever adopted divergent standards. They had for the first 16 years of ICAO's emission standards program, from 1981 to 1997. EPA declined to adopt ICAO standards based on the statutory factors in Section 231.
And were the standards that EPA adopted higher than ICAO standards? Or?
They were non-existent. They basically said we don't need to adopt these NOx standards that ICAO adopted because NOx is a problem at airports and the technology is too immature to control it cost effectively. So on that basis, they just declined to have a NOx standard for aircraft for that entire 16-year period. In 2001, they also adopted a noise standard that was more stringent than ICAO's standard. Noise is grouped with actual molecule pollutants as a pollutant under aircraft regulations. The EPA mentioned the time pressure and the technologies, the amount of data they would need to gather on technologies' applicability to aircraft across different models. They had that. The ICF model that is described at J831 to 33 lists emission reductions associated with every known fuel efficiency technology studied by ICF. And it could run that model to see what could those together produce as far as emission reductions. They only used that model to determine that ICAO's standards had no cost and no benefit. That's all they used this model for in the 3 years they had to work with it. The question about international credibility has been answered in Massachusetts versus EPA, where the Supreme Court said, we're not questioning the executive's prerogative over foreign affairs, but EPA still has to do the job that Congress assigned it. Here, all we're asking is for EPA to base its standards on the Section 231 factors and on the record.
What about its argument that here they also have to work with FAA, that FAA has its own standards, it arguably has primary responsibility for many of these issues. And so therefore, it's not just about international harmonization, but it's also about kind of making things consistent across executive branch agencies domestically.
Sure. So FAA's duty here under Section 233 is to implement and ensure compliance with the emission standards that EPA promulgates. So certainly, EPA is not mandating certain technologies. It will have certain technologies or measures in mind. So before in the fuel venting standards adopted in 1973, it had operational measures in mind when it created this emission standard, and it left it to FAA to regulate it. I see my time is about to expire. I have a few more points to make. May I briefly conclude? NACA did consider the statutory factors. They did consider alternatives. It wasn't a more stringent NOx standard because the record did not show that there was an obvious alternative to study. But they did consider in-production standards, and they rejected that alternative under the statutory Section 231 factors. That's at 70 FR 69, 678, 81. In conclusion, I would just ask that the aircraft rule be remanded and for reconsideration consistent with Section 231.
Thank you. Case is submitted.